The right to an effective remedy. The right to an effective remedy is codified in Article 2, Paragraph 3 of the International Covenant on Civil and Political Rights, ICCPR. Each state party is not only required to respect the rights of individuals contained in the ICCPR, but they must also provide an effective remedy if any of those rights are violated. Other international treaties contain similar provisions that reinforce this right. These are CEDAW, ICERD, and CAT, which are all ratified in New Zealand. For example, Article 6 of the ICERD provides that state parties shall assure to everyone within their jurisdiction effective protection and remedies. Paragraph 5 of the Vienna Declaration and Programme of Action states that all rights are universal, indivisible, interdependent, and interrelated. However, the right to an effective remedy is arguably the most important human right. The main reasons are that it provides recognition for violation, equality for all, strengthens domestic frameworks, and underpins all other human rights. The first reason why the right to an effective remedy is the most important human right is because it recognises that an individual's human rights have been violated. It provides reparation for victims and brings perpetrators of human rights abuses to justice. Furthermore, it holds states to account. It is often difficult for individuals to see what the government is doing to protect their human rights. This is a way for individuals to check up on the government. If human rights abusers were not penalised and the state was not subjected to social judgment, there would be less pressure to implement change. Therefore, the right to an effective remedy helps expose human rights issues and raises awareness of violations among states and the wider population. The second reason why the right to an effective remedy is the most important human right is because it ensures that individuals whose rights have been violated are treated equally. This minimises the risk that minorities and vulnerable individuals are treated differently because an effective remedy is available to everyone. Therefore, the right to an effective remedy is not only a fundamental human right, but it is also crucial in upholding the rule of law. It ensures that everyone is treated equally and fairly under international law. The third reason why the right to an effective remedy is the most important human right is because it strengthens domestic legal frameworks. Article 2, Paragraph 3b and c of the ICCPR require state parties to ensure that a person claiming a remedy has their rights determined by a competent authority, and that the remedy will be enforced when granted. This requires governments to consider their obligations to provide an effective remedy when drafting legislation or policies concerning human rights. Governments must adopt appropriate measures to ensure that they are fulfilling their international obligations. This raises awareness of human rights among government officials, which in turn helps protect individuals from human rights violations. Perhaps the most pertinent reason why the right to an effective remedy is the most important human right is because it underpins all other human rights. Elias C.J. noted, "Without such vindication, the rights affirmed for all people in the New Zealand Bill of Rights Act, NZ Bora, would be hollow." Although this quote refers to NZ Bora, the same reasoning can be applied to international human rights instruments. If victims of human rights violations could not seek reparation, then it would render human rights instruments merely aspirational and empty statements. Although the right to an effective remedy is considered a second-generation right, it is unique as it affects and upholds all first, second, and third-generation rights. Under the tripartite typology, states are obliged to respect, protect, and fulfil human rights. The right to an effective remedy is central to this obligation, particularly the fulfil requirement. Without it, states would struggle to protect all other human rights. The majority of New Zealand's fundamental human rights are codified in NZ Bora and the Human Rights Act 1993. As required under Article 2, Paragraph 3 of the ICCPR, New Zealand has many competent authorities to consider any person claiming for a remedy. However, there are still occasions where victims are left without an effective cause of action. In cases where an Act does not provide for an effective remedy, the courts have intervened to ensure that New Zealand complies with its international obligations. In Simpson and Attorney General, the Court of Appeal upheld an award of damages for a breach of NZ BORA, even though there was no express provision in the Act concerning remedies. Hardy Boys J commented that the courts are not only to observe the bill in the discharge of their own duties, but are able to grant appropriate and effective remedies where rights have been infringed. This is particularly important in New Zealand because we do not have a written constitution, so the courts do not have the power to strike down legislation that is inconsistent with it. Therefore, the court can instead use the right to an effective remedy as a mechanism to protect individuals from human rights violations. Therefore, the right to an effective remedy not only ensures that justice is served in response to human rights violations, but also that all other human rights are upheld. Without it, domestic and international human rights instruments would not adequately protect the rights of individuals. It ensures that states comply with their international obligations and provides individuals and the international community with a platform to question state actions. Therefore, although all human rights are considered indivisible, it is clear why the right to an effective remedy is arguably the most important human right.